Start. The appellant authority therefore filed an application before the appellate court praying for recall of the order dated 25/4/2014 and sought restoration of their appeal for its hearing on the merits. By order dated 29/6/2016, the appellate court dismissed the application, which gave rise to filing of the writ petition by the appellant authority under Article 227 of the Constitution of India before the High Court of Karnataka at Bengaluru. By impugned order, the High Court dismissed the writ petition and affirmed the order of the appellate court, which has given rise to filing of this appeal by way of special leave by the defendant in this court. Next para. So the short question which arises for consideration in this appeal is whether the appellate court and the High Court were justified in dismissing the application in bracket MA number 77/2014 close the bracket filed by the appellant authority in bracket defendant and were therefore justified in refusing to restore their first appeal. Next para. Heard Mr. Mahesh Thakur, learned counsel for the appellant authority, and Mr. Anand Sanjay M. Nali, learned counsel for the respondent. Next para. Having heard the learned counsel for the parties and on perusal of the record of the case, we are inclined to allow the appeal, set aside the impugned order and also the order dated 29/6/2016 passed by the principal district and sessions judge in MA number 77 of 2014, and in consequence allow the application filed by the appellant authority in bracket defendant and recall the order dated 25/4/2014 passed by the appellate court. Next para. At the outset, we consider it apposite to clarify one legal position which was rightly brought to our notice by the learned counsel for the appellant authority. Next para. The first appeal, open the bracket, RA number 370/2012 close the bracket, filed by the appellant authority, suffered dismissal in default on 25/4/2014 because on that day none appeared for them when the appeal was called on for hearing. Next para. Such dismissal attracted the provisions of Order 41, Rule 19 of the Code, and therefore the appeal could be readmitted for hearing at the instance of the appellant authority only by taking recourse to the provisions of Order 41, Rule 19, and subject to their making out a sufficient cause which prevented them from appearing on 25th 2014 when the appeal was called on for hearing.